right, this is case number 21-160. This is Wong Kim, MD, doing business as Farmbrook Interventional Pain and EMG versus City of Detroit. Your appearance at this time for Farmbrook, please. Counsel for Wong Kim. All right, do I have City of Detroit on this matter?
Yes, Your Honor. Philip Hiltner, P77913 for defendant, City of Detroit.
All right, thank you, counsel. Have you spoken with plaintiff counsel or anybody on the other side of this, sir?
Yes, Your Honor. We actually, he agreed. We submitted an order of dismissal without prejudice. You might not have it yet. I think it was late last week, probably, that we submitted the order.
All right, very well, Mr. Hillman. I do not have that. It is not populated to the file. I will take your word as an officer of the court, and I'll put a notation here indicating that the matter has been dismissed by way of stipulation. I will await the order, and so the file is noted in the court. Thank you, sir.
Okay, thank you, Your Honor. Take care.
All right, this is case number 21-164-776. This is Ford Transport Incorporated versus Michigan Auto Insurance Placement. The court sent this matter over after issuing a bench warrant where the underlying claimant did not appear for a deposition. Your appearance for the plaintiff with Ford Transportation.
Eric Noga appearing on behalf of plaintiffs.
All right, and your P number, if you will, for the record, sir.
83611.
All right, thank you, Mr. Nolan. For the defendant, Michigan Auto, please, your appearance at this time, please. Mr. Nova, you're here. Have you spoke with someone from the Zosmer office?
Not this morning, Your Honor. If you give me a moment, I can see who I have on this one and give them a call.
Yeah, try it. Go ahead and do that, sir, and I'll come back. I'll come back to the matter. I want to see what the status of things are in that regard. I'll come right back to you.
Understood. Thank you, Your Honor.
All right, the court now calls case number 21-166-227. This is Cisco Detroit LLC versus Deering Company Incorporated, doing business as Birch Marketplace. Today is date and time set for a review regarding this matter. Your appearance for Cisco at this time, please.
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of plaintiff in this matter.
All right, thank you, Mr. Kim, and good morning to you.
Good morning, Your Honor.
For Deering Company, your appearance at this time, please.
Attorney Linda Bernard, P24740. Good morning, Your Honor.
Good morning to you, Mr. Bernard. It's good to see you on this Monday morning. All right, I know that the last time we were here, Mr. Bernard, you were coming in the first instance, that I believe that you filed an answer. Somebody update me on the status of things right now.
Your Honor, we did file an answer. Our answer indicates that Mr. Deering did not sign the application for credit. Mr. Kim and I have not had an opportunity to speak yet. It was an electronic signature. Mr. Deering said it is not his application, but I want to talk to Mr. Kim, obviously at his convenience, to see, what this is all about. We have an idea about how this was signed, but it was not signed by Mr. Deering.
I'll take a moment then, Mr. Kim and Ms. Bernard, to place you in the breakout room to at least begin to broach this subject, and of course I'll give you the option to come back in, and we'll find a way forward after we have something of a discussion. So I'm sending you, Ms. Bernard, an invitation for breakout room. Receiving the same, and I will stand down on the matter. I see that, I believe Mr. Deering is here. Would you like for him to come to the breakout room as well, Madam Council?
Yes, thank you, Your Honor.
All right, thank you. I'm going to send Mr. Deering there as well. There you go. And come on back in once you have a chance to talk. We'll find out what we need to do. Mr. Noga, sir, you have to keep your device on mute until your case is called. Mr. Noga, are you ready in this regard, or I know that you're here, but you spoke to the other side yet? All right, the court now calls case number 21-171657. This is Oakland Community College versus Colin Emmanuel Villanova. It appears as Villanue. VA is the last name. Matters before the court. I have an ex parte motion to amend caption. This looks like the nature of the motion. I do see a complaint sounding in 3 counts. Alleging damages in excess of $1,900 for the plaintiff in this matter. That is Oakland Community College. Your appearance at this time.
Good morning, Your Honor. Brian Narlock, P number 83990, appearing today on behalf of plaintiff.
All right, thank you, counsel. Good morning to you, sir. I'm looking now for Mr. Emmanuel, last name Coleman. Say something if you're on this zone. And if that's the person, I'm muted, hit *6 and come back in.
Good morning.
Good morning. What's your name, sir?
Emmanuel Villanueva.
All right, thank you, Mr. Villarella. All right, counsel, update me on what's going on here. I know that you filed a complaint in this matter. You've asked that you have the right to amend the caption in this matter. Looks like you're asking that it. Well, tell me what you're asking the court to do at this time.
Yep. So, Your Honor, at this time, we're just asking to amend our complaint. It looks like the caption was filed under plaintiff Oakland Community College by mistake, and the proper plaintiff should be named Credit Union 1. So we are just requesting at this time, pursuant to Michigan Court Rule 2.1118A2, to amend our complaint to reflect the proper plaintiff at this time.
All right. You got some noise in the. Do you have a child there?
Yes.
All right.
Because I need a translator, a Spanish translator.
You sound like you're able to hear me pretty well. I will give you a translator going forward in this case. The request to amend the caption to replace Oakland Community College as credit union number 1, I will grant that petition in regard to this matter. So the caption will be amended. Now, I see that you have not filed an answer to the complaint in this matter. Have you spoken with a lawyer regarding filing an answer?
I need a translator.
Did you understand
Please.
my question though, didn't you? You did understand my question, right?
No, I didn't understand.
You understand it now. You understand everything I'm talking to you about except my question. My question is, have you spoken with a lawyer regarding this matter yet?
No.
Okay, so you're definitely going to need to get somebody involved in this matter. What the court does is the court appoints somebody to talk with you at court, but not somebody to give you legal representation. You have to get somebody to give you legal representation. That's different from an interpreter. And the only reason I'm telling you this is because you've been able to communicate with me, and that's okay. If you need deeper communication with somebody, I will certainly appoint you somebody. But if you're looking for somebody that will help you to represent you in the case, you need a lawyer to do that, not a translator. I can get you a translator.
No,
I'm listening to you.
I can understand a little bit English. That's not a big deal. I don't need nobody, no lawyer right now. because I don't understand why they are. I'm over here right now in this moment, sir. Your Honor, because the deal that I have, it was credit union. I don't know these people. I don't know why I'm over here. I don't know why the banks sell this my information to this college community. I don't know.
Okay, I got you. All right, so the big challenge here is that you have to file an answer to this complaint, or otherwise you're going to end up getting a default issued against you. So that's it. That's the thing I'm concerned about. Hold on one second here. Let me look at something. Yeah, and they're saying that that you received a complaint back in December, and so you would need to hurry up and get an answer. Otherwise, they'll win the case by default without you having anything to say.
I already get in contact with this company, and like a few months ago, before I came over here to this courts day,
Yes.
and we talked by phone, and we made an agreement to make a payment. Even if this is I don't know this company, and I make agreement with them to make payments a month, and they don't answer me. They just bring me to court. I got $6, $6 and one boy. They're all little. I pay child support, and only my income is only $400. And I talked to them and let them know, please give me a final number, and they don't want to give me no break. The only thing I can do is make payments a month, probably $50. I want to pay, but
All right. So they're saying that the debt here is approximately $2,000, $1,900 and something dollars. I mean, certainly if you agree that there is a debt here, you can petition the court even to get a partial payment where I can set up something for you to pay a certain amount a month, or you can talk with the attorney and see if you can figure out an amount that they will agree to try to get this resolved. So I'm going to stop right there. What I'm going to do is I'm going to give you a moment to speak with the attorney on the other side, just to see if you can reach some agreement regarding the number and the amount to pay. If not, you still come back and talk to me, and we'll figure out what to do with the case. But if you're agreeing that there's a certain amount of money owed, then the next step is to figure out how you pay it. And you have the right to ask the court to give you a certain number, a certain payment a month, so on and so forth. And the court can make a decision based upon the resources as to how much your monthly obligation should be on the payment. So I'm going to send you to breakout room number 2 with Mr. Norlock, and it's just to try to see if you can reach a resolution. If you can, we'll find a way to go forward from there. If not, then you come back in, the court will decide what we do next as relates to this case. So there's your notification, sir. And counsel, I'm sending you a notification to breakout room number 2 as well. All right, I'll talk
Okay.
with you all.
Thank you.
okay, thank you.
All right, Mr. Norwood, thank you for reaching out here regarding this matter. Go ahead and update. We're talking about the suffix 4776. Go ahead, counsel.
Your Honor, I was able to reach Ms. Talitha Mahomes, legal assistant, who informed me that she would be speaking with her. I have nothing further beyond that. I did provide them your Zoom information. Hopefully, we should see a counsel shortly.
Okay, all right. Let's do it. Thank you for reaching out. I'll stand down and see.
Thank you, Your Honor.
Your Honor.
Yes, Mr. Kim.
Yes, just so not on the record, but they're in the room right now discussing matters. We will come on the record and just kind of do some housekeeping, and I'll get back with you shortly.
Sounds good. All right, Mr. Noga, I see that that Ms. Mahone looks like she's coming to the Zoom regarding this matter. And we're on the record regarding 201-64776. This is Ford Transportation Incorporated versus Michigan Auto Insurance Placement Facility. Mr. Noga did enter his appearance, did reach out to Ms. Mahone, and I see that she has made it into the Zoom. Now I'm waiting for Mr. Noga to come back in. Madam Counsel, your appearance on this matter, please.
Good morning, Your Honor. Talita Mahome on behalf of the MAPF. P number 79890.
All right, thank you, Counsel. I'm waiting for Mr. Noga to come back in.
Okay.
All right, in the meantime, I'm coming back on that matter, Madam Reporter. So now I'm addressing the subject 6227. That is Cisco versus Deering. The parties were in the breakout room. And all right, somebody update me Ben at this time.
Your Honor.
Your Honor, we had the opportunity to discuss the matter further. It seems like we're going to try to work out some sort of resolution. There's been some more fact clarification as to possible parties. And rather than go into the details or bore the court, we're going to try to work it out. That being said, we do have some housekeeping matters, namely the defendant in filing his original pleading had filed a motion to dismiss. I'm not sure if the court ever made a definitive ruling on that, but they've reinstituted their motion to dismiss. And while we try to resolve this matter and try to sort out how we can resolve it, we've agreed to stay any response that was necessary on that motion to dismiss. And hopefully the next thing we'll be filing with the court is a dismissal.
All right, Mr. Nari.
That is absolutely correct, Your Honor. We are, and thank you very much for allowing us to go into a breakout room. We hadn't been able to connect prior to today. And I have an idea of a potential settlement, and I'm going to propose that Mr. Kim. So he does not have to file a response to our motion to dismiss, and we're going to try to resolve this as expeditiously as possible.
So if I put a control date on it, like 30 days out, does that appear to be a sufficient amount of time to go down on this?
Yes, Your Honor, for us.
On my side as well, Your Honor.
Very well. So I will set 30 days as a control date. So that's 30 days for review. The motion to dismiss is stayed during this time before it makes a determination.
Thank you, Your Honor.
5/16 is the date that I've been given, 5/16, 2022, and I'm looking at 10 o'clock a.m. on
All right. Thank you very much, Your Honor. And happy Easter. Happy Easter to you and your family.
Likewise, thank you so much. Always good to see you. Good to see you as well, Mr. Kemp. Good day to you, Mr. Deary.
Thank you, sir.
All right. I'll talk to you soon, Linda.
Okay. Bye, Albert.
Thank you.
Well, Ms. Mahal, we waited on you, and now it seems like Mr. Nova has gotten pulled away somewhere.
Yeah.
It's okay. We'll wait a few moments.
Yeah, sorry about that, Judge. I didn't have this on my calendar for some reason, so.
Yeah, we weren't going to take any action until we at least reached out. So, establish your reputation showing up. There are some people that don't take work seriously. You've already established it.
Thank you. I appreciate that.
All right, Ms. Coleman has placed her appearance on record. Mr. Nova, you've previously indicated your appearance as well. I know that the last thing that happened regarding this was that the defendant was reaching out to depose the underlying claimant. The claimant did not show up, and the court ordered the claimant to show up, and she still didn't show up. So at least on one occasion, she did not meaningfully participate in the deposition. So I did issue a bench warrant. So Ms. Mahone, tell me the status of things with best of your knowledge.
Yes, Your Honor, I do see that the bench warrant was issued, but I don't see that we've received it back yet. So, so we basically, there's been no contact, no, I guess, communication with the claimant in this situation. I think the claimant's deposition, like we said, was necessary for this case, but obviously we have not been able to get that. So at this point, I don't really know that there's much more in terms of discovery that we can do, because we've gotten, I think, the discovery that we need from plaintiff in this matter. We just, like I said, had the outstanding claimant deposition.
All right, so I signed the order for bench warrant on the 25th of January, and it was sent out. So I don't know what.
You said, I thought it was just in March, was it not?
Let's see. All right, just one moment. All right, so yeah, okay, I got it now. I'm looking at my order. I compelled her to appear in February. I thought I remember drafting a bench warrant, and I remember receiving something from your office. You drafted one as well, correct?
Correct.
Yeah.
Yep.
My thought was that I had already did it and sent it out, and that the one that, by the time I got the one you sent, it wasn't necessary. Now I don't see any of that in the file, so I will follow up on those items. So,
I have remarks, I have information that was done in March.
is that in March?
Yeah, one of my registered action.
So yeah, I issued that order in March, so I don't know what happened. I'll have to go to the file and find out. So, Mr. Noga, what are your thoughts about this case? I mean, this can't drag on forever. I know that getting some information from the claimant is crucial in these matters. Tell me what your thoughts are.
Well, Your Honor, to be completely frank, I think that this is a current conflict in the law that was created by the June 2019 reforms. Right now, you have a situation with a claimant or an assigner or the injured party in this matter who's not showing up or cooperating, whereas the providers in this matter have cooperated completely and are both, they're directed to go to the MAIPF for these matters. To my understanding, I believe we've had a proof of loss. I think I would suggest that assignment to an insurer is perhaps a little tardy, but as far as the
Mute yourself there, sir, for just a moment. Mr. Collin, go ahead and mute yourself. So, okay, there you go. Go ahead, Mr. Nolan. I had some interference. I'm sorry, sir.
an appearance from me, Your Honor?
No, I had some interference from someone else. So I wasn't. Go ahead, sir.
Your Honor, we essentially have a law conflict here. I believe it's 3145. There's a direction from the MIPF that claimants or those making a claim through a party are required to cooperate with investigation of the MIPF or its assigns. And then in 3112, 53112, 3114, my apologies. Providers are directed to go to the MAIPF in order to seek benefits if there's not a known insurer. This is a conflict that was going to happen. We don't have directive from the Supreme Court or DIFS or the legislature at this point as to what is supposed to happen if the injured party is not participating. The language isn't clear. This is a problem that's going to exist until it's addressed by the courts or until the current Medicare fee schedule, which came into play last summer, becomes the standard operating methodology, in which case I suspect most PIP claims are just going to get paid because they will be so cheap, it's not worth the litigation or not paying them. But in these kind of gap issues where we have both a directive to go to the MAPF and bills large enough to be worth the suing over, essentially, I think we're waiting for guidance from the Supreme Court. I wish I could provide more, but I legitimately have a motion for summary disposition basically on the same issue a little later this morning at Wayne County. And I'm not sure how it's going to go. This is a problem that hasn't been resolved by the people who can resolve and have the power to do so.
So I suppose then that you will be filing that same motion or something similar in this case, because it looks like I did find the bench warrant and I see where I signed it, but I don't know what happened. We're going to make sure. Excuse me. We're going to make sure that that gets out. That gets out right away. So it sounds like to me, given that there are not a number of other issues of discovery, that that I need to simply set this for the prospect of a motion here.
Yes, Your Honor, I would ask that we do that.
Your Honor, I would only suggest, as no motion has yet been filed, that we set a trial date in order to put some kind of end point on this. If a motion comes before that time, that's fine, but I'd rather than set a hearing for a motion that has not been filed at this point, I'd rather set a trial date.
Yeah, unfortunately, you don't get to roll this morning. So what I'm gonna do is I'm gonna set a motion hearing date. And either party can file any motion that they wish to file and set it for hearing on that date, but you will have to give the other side, you have to make sure it's filed soon enough that the other side has 10 days to respond.
Right,
So
okay.
the date that I'm going to set is going to shorten the time that would normally be allowed for filing motions for summary disposition. It will shorten response times and everything, but it will give you enough time to do what you have to do. So I'm looking at May 19th. That would be the motion hearing date. 5/19/22, and that's going to be at 9:45 a.m. And whatever motions you believe that you need to file in this matter, you go ahead and file it. Just make sure that as you do so, that you allow 10 days for the opposing party to respond to the motion. And I'll hear
Yes,
it
Your
on
Honor.
that.
Yes, Your Honor.
Thank you, Your Honor.
Thank you. Good day to you. And you'll get an order regarding the new date. You'll also get that order, the bench one. I don't know what happened along the way, but we'll make sure that gets out right away as well. And then we'll see you on the day to both sides.
Thank you, Your Honor.
Thank you. Have a good morning.
All right, and we are back on the record with regard to the suffix 1657, the case that is now Credit Union 1 versus Emmanuel Villanova Coleman. Right, Counsel, if you will update me if you will regarding this matter.
Yes, Your Honor. I did have an opportunity to speak to the defendant. Looks like we were not in any. We did not come to any agreement with regards to either a settlement or a proposed payment plan. The defendant did indicate that he does owe the amounts due and owing. He has an issue with the court costs and attorney's fees. I did explain the service fee. I did agree that I'd waive the $75 attorney fee if we were to enter judgment, but at this point, there's nothing that that the parties have agreed to.
All right, so
My-
I'm coming to you, just one second. So the total amount that you're requesting is the planned amount of $1981.51 plus court costs. So what total amount did you come to, counsel?
So that would be the principal balance. We would be waiving the $75 attorney fee. So it looks like the only cost right now or just the filing fee and the service fee, which are $118.18. So that should bring a judgment balance of $2,099.69.
And you understand the number that they are looking for, correct, sir?
Yes.
Tell me what you wanted to say about this matter.
I spoke to Brian, right? Brian?
Yeah.
And I let them know that before this court date, I called them to make an agreement to pay my $9,000, by payment, $50 a month. And they never answered me back. But now they're charging me court fees. Another one who bring this case to the court because I never said that I'm not gonna pay. But I let them know that if they give me a final payment, $500 and close the case, I can do that. I only got $500, I can do that. But if you want me to pay the full amount, $9,000, I can do payment $50 a month because I got 6 kids. They're little. I pay child support. I got proof.
Stop.
And
Stop. let me stop you for, you keep saying something, 9,000. What are you talking about, 9,000?
Yeah, 1,900.
Oh,
I can pay that $50 a month, but not 2,000 because I'm not the one who bring this case to the court.
yeah, well, if you haven't paid it, the plaintiff would bring it to court. That's the way to do it.
Yes,
You don't, listen to me carefully. I mean, we have court
Yes.
systems. We don't have the situation where you come and bring your gun and collect your debt. So you have
yes,
to
I
bring it.
understand.
They filed it in court. Listen, let me say it like this. Here's what, now, I can't make the parties come together and reach any agreement. I have no power to do that. I understand what you put on the table. You put $500 to try to resolve the whole thing. And counsel has indicated that he doesn't have authority from his client to do it that way. What you might be able to do, and listen, I can't force the hand on the other side to do this. They're claiming that the debt is almost $2,100. If what you put on the table, you got to find a way to negotiate it, find a smooth spot. If what you put on this table, you say that I've got $500 I can pay now, and I'll pay the balance off at $50 a month, but I want the total amount to be $1,500. You might, I don't know if that works for them, but that's closer to trying to get this resolved. You could save $500 or $600 going that way, or some amount in between that, to negotiate 2,100 versus $500. That's, I don't know how you're going to reach an agreement at those numbers. But whenever you talk about putting a lump sum up front, oftentimes that puts you in a position to get the overall amount lowered some because of the fact that you're willing to put so much up front. But it's not typically the thing that will get you to eliminate the whole part. Whatever is left, likely pay off money or whatever to get that resolved. Go ahead, I'm listening to you.
Yes, I can pay $50 a month for the 1,900. Yeah, I can do that.
Well, the thing is that essentially what they're saying is that they will negotiate with you for something better if you are willing to, if you're committed to paying the full debt. The $50 a month, they don't want to negotiate some of the debt away if you're only willing to pay $50 a month. And the problem is that obviously you could file something with the court to show that you should have the right to pay $50 a month. But if your income is such that it seems that you should pay more than that, then any issue or order with the court might result in you having to pay more than that $50 a month. So the way that you, I see what you're doing. It sounds like to me that you'd like to try to control this and manage this in some kind of way. That makes sense. That makes a whole lot of sense. But I think that the position that you take is that you want to pay $50 a month, and the attorney, number one, is you're willing to waive the attorney fee, but the cost that they pay to the court, if you're going to pay them $50 a month, they're saying that they're not willing to waive that cost if you're going to do it that way. If you are paying something more, or if you're going to put something down, you might be able to get that court cost waived.
Before the court, I called them and I didn't know. Don't take me to the court. I pay payments, and they still bring me to court.
You told me that already. The big ears let you know that I hear it the first time. You told me that already.
Just I got the proof over here, or income of $400 a week. That's what I make, and I pay child support. I got the proof over here. I mean, I can do $50 a month, no problem. I want to pay. Believe me, I want to pay.
So is if the judgment is entered for the amount claimed, is the $50 a month something that the plaintiff is willing to stipulate to?
Yeah, yes, Your Honor.
All right, so if you agree to go forward with the judgment being entered at, what's that amount again,
$99.69.
So the judgment at $2,099.66, they're willing to agree to the $50 per month.
Okay, no problem.
All right. So then I will, counsel, if you'll submit an order to me, I will find that the parties did reach a resolution. nobody forced you into this resolution regarding this matter, Mr. Collins. Is that correct, sir? Yeah, nobody forced you into this, right?
And to be here in court, no.
I'm talking about the agreement. This is your agreement, correct?
I mean, see. Look,
Okay.
just I pay like $50 a month, and I'm gonna let God to judge these people. God will judge one day. I appreciate it. Just
Let me ask you, and I understand that. Let me ask you this. You are agreeing to pay a debt that's approximately $2,100, and you're agreeing to pay that at $50 a month. Is that correct?
I am agreed to pay $50 a month for the 1,900 that I owe, not the 2,000.
Okay, well, you don't have an agreement then. Okay, so, counsel, are you, what is your desire regarding this matter? You going to file a motion or?
Well, Your Honor, I would state as of today under Michigan Court Rule 2.111 I1 that there is no genuine issue as to any material fact, and the court does have the power and discretion to order or to enter a judgment here today based on the fact that the defendant is not disputing the amounts that are due and owing, and therefore, based on that, plaintiff is entitled to the costs. So we would request that the judgment be entered today based on that.
I think that the problem with that, counsel, is that it seems that the defendant is engaged in settlement discussions, and those settlement discussions, I can't bootstrap them to conclude that he is not disputing the claim. However, this is where it gets problematic. I have no answer to this complaint. So I suspect that Mr. Norlock is going to submit a default judgment to the court because you haven't responded to the complaint. By engaging in some discussions, obviously that's a way to try to get it resolved without doing that. If you don't have a written response, then you're in default on this already because the service occurred in December. We're now in April, and there's no written response to the complaint. At least I don't see one. Counsel, did you receive an answer?
We have not, Your Honor.
Yeah. So that's the problem, sir. Procedurally, you have to file an answer, and you haven't filed one, and you're past the time to do that. So I'm going to, if counsel is petitioning that the court enter a default, then I'll enter a default because you haven't filed anything.
Yes, Your Honor. Plaintiff would be requesting that at this time.
Yeah. So I will enter the default, and I'll anticipate the submission of a judgment. Once you get the judgment, you can petition the court to make partial payments, and the court will make a decision in that regard. Let me just say, because I think here's a part of your consideration. If you get this resolved and you're controlling it by resolving it, then as a part of that resolution, you could reach a plan where once you pay this, that the case gets dismissed. Whereas I entered a default judgment, now you have a judgment on your record, and everywhere you go, that judgment is going to come up as a debt judgment against you. That's why I sent you in the breakout room to try to talk about this to see if there's a way that you could actually resolve it. Now what the dispute is over like $200. And for $200, you're going to end up with a judgment on your credit reporting and so on and so forth. And I don't know how much sense that makes, but I'm in it further than I want to be in it now, because I know that you're not represented by counsel. I'm trying to give you a little bit of wisdom as to how to think about this, while at the same time respecting the right that counsel has on behalf of his client to simply ask for a default. And that's what he asked for. He submitted a default judgment to me. I'm going to sign it. That's where this case is.
I just want to make payments.
Okay. All right,
$50 a month.
Yeah, I understand. All right, counsel, I will await your judgment, and then once you get the judgment, just file a petition for partial payments, and I'll consider it and make a decision on that. Okay. All right. All the best to you. Thank you. Good day to both.
Thank you, Your Honor.